So good morning, Barton.
Good morning.
Well, thank you again to take your time in this busy schedule that you have. I know you are super busy, not just for all the work that you do, but trying to help agents on these changes that the National Association of Realtors are doing in place on August the 17th, but right now boards, Miami boards and Orlando board, like I know already, they begin to do the changes. But let me introduce first um, Mr. Barton Strock, my only source, my best source of real estate law and closing. So Barton had the Bachelor Arts of received his Bachelor of Arts from Brooklyn College in 1971 and the Juris Doctorate from Brooklyn Law School in 1977. And in
So I'm
Florida.
old. I'm old. That's all you say.
Okay, no, you have a lot of experience. We all are. He moved to Florida in 1979. Thanks God, he chose us as his home, and he owns or his partner on Strock Cohen and Zipper. It's an addition of all he works in residential and commercial real estate. It's also practice areas in real estate litigation, foreclosure defense, landlord and tenant, title insurance claims, and business organization, as many more. He's also member of the Florida Bar and it's real property. My tongue is getting very bad today. Probate and Trust Law, Trio Law, Business Law section, and also member of the Broward County Bar of Association, South Broward Board of Realtors, as Miami Board of Realtors too, business networking, and also certified Supreme Court of Florida Circuit Civil Mediator. I cannot say more about you. You are one of the most experienced real estate attorneys in Florida, and I am very blessed that I have you in my side every time I be into any transaction or any problem that have to be resolved. You, for me, the best, and thank you so much. So we are talking today about the National Association of Realtors settlement and all the forms that are getting in place in August 17. And right now, many realtors are going into the changes of the MLS. When they open the MLS, they will not see the compensation for the buyer's agent. So many boards begin the beginning of August, and Miami board and Broward West Palm Beach, all the South, on August the 13th. So for some agents didn't see it because it gets into when you go down, you see the compensation, but now it shows nothing. And the buyers also have to be towards some forms, they have to be signed, and now agents have to communicate with their buyers and sellers to get into understanding about all the changes and what can be done or not. So that is your expertise, and again, welcome.
Thank you, Jackie. All right. So today's August 15th. I don't know why you're all here. What's your hurry? We have till the 17th before the new forms go into effect. So you have plenty of time. My job today is to do what I've done for over 40 years, is tell you that there's nothing to panic about. You know, when you first started in real estate, you got a license, you took classes, you got a license. Florida Association of Realtors and the Florida Bar gave you some forms to use, but you had to learn how to sell. Nobody taught you that. There are some people that could sell anything, including the Brooklyn Bridge. And there are some people that have difficulty selling. So you had to do all three. You had to be a technician and get your license, learn how to fill in the forms, become a real estate professional, but you also had to be a salesperson. Pretty much the same as me as a lawyer. And no one ever taught me how to sell myself in school. I had to learn that on my own. And so nothing has really changed for you. You're just going to have to learn that your product has been new and revised, and it's going to change. But the change is not that radical, depending upon how you understand it and how you present it. So normally, if I wanted to go to the store across the street from my office, I'm in downtown Fort Lauderdale, I would walk across the street. Now I have to walk to the end of the block, cross the street, and walk back to the store. That's the difference. I'm getting to the same location. I just have to take a different path. And that's what I'm here to show you today. I'm here to show you how your forms have changed, what you need to fill in them. And even though I have never sold a piece of real property in my life, I have never gone on a listing appointment. I have never shown I have shown buyers' houses because the realtor asked me to come because it was very crowded that day. She expected a big open house, and I wound up helping her show the house. But you just have to learn to tell them the new rules and explain how it works. So briefly, let me tell you about where we are, what's happened, so you can understand the fill-in-the-blank forms, okay?
Yes.
So we have this settlement between the National Association of Realtors and some plaintiffs in Missouri that, one, it eliminates mandatory offers of compensation in the multiple listing services. It doesn't eliminate shared compensation. It just eliminates it in the multiple listing services, okay?
Yes.
It ensures that all compensation agreements are transparent. So it's very clear what's going on. There's a lot of disclosures, and it's agreed upon by all parties, okay? So here's the forms we have. The right of sale listing agreement, which we've used for years, is slightly changed to eliminate all references to shared compensation and to make all these disclosures, okay? When I tell you about disclosures, what I'm talking about is you pick up a cigarette package, for those of you that still do, and it says, if you smoke these cigarettes long enough, you're gonna die. Or what's this new lady on TV? Her toes come off. So have you seen that one, Jackie?
No.
She you don't want to see it. She lost her toe, and they show it on TV.
Oh yeah, ladies that have so many issues.
It's worse than the lady who lost her jawbone. But that's full disclosure. It says that you smoke these cigarettes, it will kill you. So now it says you can't do these things, okay?
Yes.
So understand that's the purpose of these forms. For years and years, the National Association of Realtors asked realtors you should be using a buyer's agreement before you show a house. Now it's mandatory. You have to use a property pre-touring agreement, okay? It's a very simple form. Yep. It really does very little other than give disclosures and authorize you to show a house. There are two other forms that go along with that form. One is the revised showing agreement, which the realtor the buyer authorizes to show you some houses. And then there's the exclusive buyer brokerage agreement, which makes you the exclusive brokerage agent for that buyer. And it tells you to go look at MLS and go look for houses for them, whatever they want to see, you're going to show them. And that one gives you a little more protection than the others. Okay, and we'll go through those. And then there are 4 shared compensation agreements. So there are 2 things that could happen. Either the seller could agree to pay the buyer's broker,
Yes.
or the seller's broker could agree to pay the buyer's broker. Much the same for any of you who do commercial. That's what it says at the bottom of the CC5 commercial contract. Who's going to pay the buyer's broker? Is it going to be the seller or the seller's broker? Okay. So those are the forms, and we're going to get to them in a minute. What's the changes? Mandatory compensation is eliminated. Written agreements, transparency. That's the whole reason for this. So here's some of the examples before we get to the form, because I have found doing this seminar a few times, if I tell you about the forms, what their purpose is, and what you do when we get to them, you'll say, and we fill in the blank, you'll say, oh yeah, this makes sense. Okay, so there's the possibility. Let me tell you the thoughts that I have right off the bat that all of you have. There is not a buyer in the world who really wants the budget to pay you to show them a house.
Yeah.
Okay. Mm-hmm. And as of Saturday, all the sellers are going to say, I read the news and I don't want to pay the buyer's compensation. Mm-hmm. And as an anecdote as to where that comes from is that in this case in Missouri, the buyer's agent told tell the buyer, let's not look at that house until it's raining so we could see if the basement leaks or not, if it's moist or damp down there.
Yeah, well.
And so we know it's not in Florida, at least not in South Florida. And the seller said, why am I paying for this agent, the buyer's agent, who is doing absolutely nothing for me but cutting my price? Yeah. Why am I, they're trying to find out all things wrong with my house, why they should make a lower offer, and why am I paying them their commission for that? And that's pretty much what sold everybody on it, okay, except his house. So understand that's what we're dealing with. So buyers don't want to pay you if you're a showing agent, if you're a buyer's agent, and sellers don't want to pay you if you're a listing agent, if you're a buyer's agent. Mm-hmm. So it now becomes incumbent upon the seller to be educated. And that's the listing agent's job, to educate them. That's now part of your sales pitch. And the same thing with the buyer's agent. And I'll show that to you as we go through. What can happen if you violate these laws? One, you could be sanctioned by the NAR. And by the way, that's only if you're a member of the NAR. And these rules don't apply to you if you're not a, quote, realtor. If you're just a if you're a real estate agent, but you're not a member of the NAR, these rules don't apply to you. However, all these forms come from Florida Realtors and Florida Bar, pretty much comply with the settlement agreement. It's not law, it's agreement, and nobody's taking the chance, okay? So NAR could sanction you or fine you. More likely, someone could sue you, most likely a seller or something, by your failure to follow the new regulations. You could be disciplined by the Department of Professional Regulation and Florida Real Estate Commission. And I haven't heard this mentioned by any of the boards of realtors talks I've heard about, but I've heard this from American Land Title Association and the Florida Bar. This settlement is a result of the federal district court in Missouri, where the NAR said all our agents are going to do this. And if you don't do that, you may be held in contempt of court, a federal court in Missouri. I think it would take a pretty egregious case to do that, but it's a possibility, okay? So you need to learn this, and it's really very simple, and you need to think about it and do it, okay? Here's my general thoughts. So remember, so let's talk about listing agents first, because that's where it starts. Mm-hmm. Listing agent's going to go with an exclusive right of sale listing agreement and go to the seller and say, listen, I think you should offer. You don't have to. It doesn't say anymore in the exclusive right of sale listing agreement that this office usually cooperates with the
selling
the selling agent.
Mm-hmm.
So you have to. So there's an option. The seller could authorize you to offer such a shared commission, but it can't be in the MLS. It's in your listing agreement. Okay. Your job is to explain to the seller, listen, if I don't offer this, no one's going to show your house because buyers don't have the money to pay. They can't include a fee in their mortgage. It would be over and above their down payment, over and above their closing costs, and not included in their mortgage because it's not part of the appraised value of the house.
Mm-hmm.
Okay? So we need to work a separate agreement with the buyer's broker as to how they're going to be paid. Because if I don't get that word out there, they're going to look on MLS and not show your house, even though it doesn't show on MLS. Okay? So how do you, once you convince the seller that they can do that, that they should do that, how do you put out the word to buyer's agents as the listing agent that there is going to be a commission available, a shared commission? Okay. Probably the easiest way is a hanger rider from the sign, a hanger from the sign. Buyer's share, buyer's broker's commission, whatever the word is. I'm sure your local board will come up with some language, okay?
Yeah.
But instead of it saying 3-2 with pool, it's going to say we pay the buyer's commission, okay?
Yes.
You could put it on your website. So if you have all your listings on your website, it could say what the seller is willing to do.
Mm-hmm.
You cannot put your website on the comments in the MLS and to click on that and show that. That's the one-click rule.
Yeah.
The two-click rule is what gets past it. So if you put a link to your website and you have a landing page that introduces your company, maybe shows a couple of your listings and says, if you want to learn about shared commissions or see our listings with shared commissions, click here. And you have another link. And that goes to all the listings with the shared commissions. Okay? It just can't be one link. Got to be two links. You need a landing page. Okay? Put it on any, so way back in the beginning when this settlement was reached, I did my first seminars, I said, well, you could put it on any site that does not pull fees from the MLS. But after Saturday, no one's pulling fees from the MLS because the fees can't be posted. So we're going to have to see what happens with Zillow and Realtor.com and something. You know, you may be able to modify your listings there. There's a whole new business for them, you know, to allow you to modify your listing there.
Yeah, I saw that some listing put on the broker's remarks that seller will consider buyer's concession if it's placed on at the time of the offer, but they don't.
You cannot put that on the MLS like that. Okay, that's a violation. You can. So any type of off MLS negotiations by real estate professionals. Hello, listing agent. I want to show the house at such and such. Are you offering shared compensation? How much? Okay. I'll submit it with the offer. Okay, thank you. Okay.
So that means that the listing agent have to answer the phone.
Discount listing agents who just put it on MLS probably will not do well under this system. Okay. Buyer's agents, part-timers who don't have time to go look for which properties you can show and which you can't, they may have a little difficulty.
Yes.
Okay. You can still offer concessions on MLS for closing costs, repair credits, etc. No change to that. But concessions may not be limited to or conditioned on brokerage fees. Okay.
Yes.
I don't think, and none of us know for sure, I don't think you could put what you've seen, Jackie. I don't think you can mention shared commission on MLS at all.
No, nothing.
Okay.
No.
So the seller or buyer can agree to pay the buyer's broker fee directly. Someone asked me, well, what about if I want to pay the buyer directly? No, you can't share a commission with the buyer. Okay? They're not a licensed agent. It can be written to the offer as a negotiated settlement, seller payment to the buyer to pay the buyer's broker's fee directly. In the new exclusive right of sale listing agreement, the listing agent is still required to present all offers. What happens if your seller says to you, I'm not paying any buyer's commission? And you get an offer that says, you know, this is condition. Part of this offer is that you pay 2.5% buyer's commission. You still have to present it.
Yes.
It's an offer. All right. Who disproportionately, we know what part of the population will be disproportionately not served by this new rule. So the Federal Trade Commission will be back next year reopening their lawsuit. We're sure of that. So
I have here one of the agents that said that a realtor just got fined because of the realtor remarks. When they try to put on the realtor remarks that the seller will be paying compensation to the seller.
Right. So this applies to 1 to 4 family residential housing units. If you have a 5-unit building, that's a commercial property, it doesn't apply. This only applies to residential, which is defined as 1 to 4 family units, okay?
Okay.
1 to 4 residential units.
But I saw also that the lease in the MLS, they also remove the compensation for lease. So because it's a residential, so
this
that
applies to lease also.
Okay.
All these rules apply to leases also, okay? So I could see with the additional work that's going to have to be done to find out if there is a commission, I could see some of the lease commissions get higher. And we'll get to the point where the buyer says, well, I'll just go to the seller's agent and, you know, I won't deal with you for a commission, okay? I'll find the listing on realtor.com. I'll go and see it, and I'll tell you what to say on that. So, so prior to showing the home, the buyer must show to the buyer's agent must show to the buyer a specific fee I'm going to charge you to show this home. And it's got to be either a flat amount or objectively ascertainable. So if there's a formula, that's objectively ascertainable, 3% of the purchase price, okay? Buyer's agent may not accept any amount in excess of the amount agreed to with the buyer. Can accept less, but not more, and make sure the closing agent knows of the fee agreement, both sides, okay?
So if the buyer, we have 3 forms and 1 modification of any of the 2 forms. So
I got 10 forms for you here, okay?
Okay.
Quickly. Here's the new exclusive right of sale listing agreement. July 2024, okay? So broker obligations has been changed. So it says you're going to continue to make diligent, continued efforts in accordance with this agreement, but this has been moved somewhere else, okay?
Yeah.
So this is not new, but it's been moved here. So your diligent and continued efforts include, except not in the seller's best interest, cooperating and communicating with other brokers and making the property available for showings. What's in the seller's best interest, okay? So is it if someone calls up to you and say, listen, I'll give you full price, but you got to give me 2.5%. To me, that's in the seller's best interest. So you could set up a showing, okay? More important, you have the same rules for compensation for you. That's word for word, hasn't changed, okay? The total purchase price or a flat fee, for an option, for a lease, okay? But paragraph 9 that you're used to, where it says how much you're authorized to give to a cooperating broker, no longer exists. It has been replaced in full with disclosures. Notice to seller regarding buyer's brokers. The buyer's broker, even if compensated by seller or broker, so the seller or the broker can pay them, will provide services for the buyer. They're letting them know they're not doing anything for you. Yes, you still have your transaction brokerage duty of honesty, but the seller may be advised and is aware that seller may, but is not required to compensate buyer's broker upon closing. That's great, but how are we going to get someone to closing if we can't show them your house because you're not offering anything? Seller may choose to enter into a separate written agreement to pay buyer's broker, or may approve broker to pay buyer's broker in accordance with paragraph 10, which is below, you'll see. Seller also understands that the buyer's broker may include this broker if broker also works with the buyer on this transaction. So you got full disclosures here. If this occurs during the duration of the listing, broker will be entitled to the compensation in paragraph 8 for services performed for seller, as well as a buyer's broker compensation in paragraph 10A for services performed for buyer. The seller should therefore take this into consideration when negotiating compensation. Broker may receive separate compensation from buyer for services rendered to by broker, okay? So everything that could possibly happen is disclosed here. And here it takes that the seller will authorize broker to offer compensation to buyer's broker in the amount of blank percent of the purchase price or a flat fee, okay?
Yes.
And it also says that seller authorizes broker to compensate buyer's broker from seller. So it all adds up to the same thing. If you decide to accept 6%, then the seller is going to authorize you, the broker, to pay 3%. Making up the numbers. If you accept 3%, then you're going to have the seller agree to pay the other 3 or 2.5%. Okay? So you just have to, you can't take 3% and then agree to pay 3% to the other side. It has to come from the seller. Someone's going to screw that up, I promise you.
Yes.
Or no compensation will be offered to buyer's broker. What happens if the seller says that? Are you going to say, you're an a-hole, I'm not going to take your listing? No. You're going to say, I'll take your listing, but after 3 weeks, when I show you that no one sees your house, will you agree to reconsider? How does that sound?
Okay. Everything's negotiable, always be.
But sometimes you have to beat his head into the wall to show him no one's looking at his house. Okay?
Well, actually, it's I have one listing that the seller said that he see on the news that it's illegal, and it's that I was trying to explain to him that first it was not illegal, it was not showing on the MLS, but always I have to go for the old listing to the new listing and said basically it's one commission before we share, but now you have the option if you want to do it in this way and the old way, this way or not. And we don't have any choice. And at the end, he agreed. He said, like, okay, let's figure it out this, and we are on the contract.
Right. So what we have is that there's it's not illegal. It's a matter of now you have forms to put in the seller's face to show them. Okay? Everything else is exactly the same. Those are the only changes. So now the listing agent has shown the buyer, has shown the seller the light of day. You need to do that. What happens next? You get a call. I don't know what I did here. You get a call from a buyer saying, please show me a property. Okay? So before you could show them a property, they must fill out this form. Okay? How did I do here? Okay. So this is, I am a real estate licensee with XYZ brokerage. Consumer, buyer is not because this is consumer protection, the buyer is now the consumer, okay? Consumer will use broker services to view properties the parties mutually agree on. So there's no agreement here as to which property you're going to see and how long it's going to last, okay? I'm going to show it to you for one day today, 6 months, we don't know, okay? That's why there are other agreements. And here's your disclosures. Buyer, brokerage compensations are not set by law and are fully negotiable. You do not owe broker any compensation at this time. I lost my place. If you wish to work with broker to purchase property, broker's compensation for services broker provides to you will be as follows, unless amended in writing. Everything has to be amended in writing. And we have forms to amend all the forms. So you're either going to get a flat fee or you're going to get a percentage of the purchase price plus whatever your transaction fee is. Okay. Other. So I would check other and add to that consumer or buyer authorizes broker to only show properties that offer compensation to broker. Okay?
Yep.
So this is how you show your buyer client, look, I'm not taking any money from you. It's not going to cost you any extra. I will find the properties that allow me to get paid and it doesn't come out of your pocket. Okay?
So one question. This property pre-touring agreement have to be signed before go to the others two forms?
This has to be signed before you show them a property.
Okay.
Okay? Now, it tells you if you wish to work with broker may ask you to sign a separate agreement detailing the parties' responsibilities during the sale. Okay? So this is letting you know there's another agreement. Seller or listing broker may agree to pay some of all the above compensation. If a seller or lister broker agrees to pay, broker will reduce the amount you owe accordingly. So broker's compensation from any source will not exceed the amount of the compensation in the written agreement with you. Okay?
Yes.
So you can accept less, but it can never be more.
Okay. And also accepting less, because we have an agreement signed, we have to do the modification?
I would do it.
Okay.
You don't have to. Sometimes you don't know, but I would get it signed just to be sure. Okay? So this really is pretty useless for you. You know, yes, it's an agreement, but you're better off having one of the other two agreements signed also. Why they didn't take this and put this disclosure just at the top of the showing agreement or the exclusive buyer's agent agreement, I don't know. It probably would have been better, but maybe you need the time to sell the buyer on the new system. So where do you go next? You go to a showing agreement. And the showing agreement just says, I'm going to show you the following property or properties, okay? This is limited to the buyer has asked you to show you a few properties, okay? Compensation is exactly as it is on the listing agreement, where it says how much the buyer is going to pay you. Compensation by receipt. So if any broker comes in if the money comes in from the owner's broker, then they don't have to pay you, okay?
Same.
You can get a retainer. I've already heard some of the larger brokerages are not allowing retainers at this point till they see how that works out. Additional terms, that's where you're putting in. Only show me properties where the seller is going to pay the selling agent's commission, okay? And here's the disclosures. Brokerage commissions are not set by law and are fully negotiable. Buyer may not receive compensation from any source that it exceeds the amount or rate agreed with consumer. So you can accept less, but you cannot accept more. Okay? So then we have, let's say you show this buyer a couple of houses. And you say, okay, we seem to getting along well, but we haven't seen anything. How about if you hire me as your exclusive buyer brokerage agreement? It's the same price, but now I'm going to search MLS for properties for you. Instead of you going to realtor.com, you and I are now going to have an agreement that I'm going to be your exclusive broker for all properties. And so now it doesn't list, it just lists type of property and location. So what's it going to be? What are they looking for? Are they buying new construction? So you're going to put in there type of property, new construction. You can make it as broad as possible.
Yep.
You could say in Orange County or Broward County. Or you could say Pembroke Pines and the surrounding areas of Broward County. You don't want to limit it too much. You want to keep it broad. Vacant land, including whatever, or 3-2 residentials. Keep it broad, okay? And this is pretty much similar to everything else. There's nothing here that's special. Again, they could pay a retainer. Again, the same compensation that they're going to give you, exactly the same that can be paid by the other side. But here you get more protection for the work you're doing, going to MLS and doing it. You got a protection period, which you don't have in the showing agreement. You have a conditional termination right, which you don't have in the showing agreement. By the way, they all have dispute resolution, and I really recommend not to agree to arbitration. It's a pain in the butt and costs you more money.
Yeah.
The broker could assign this agreement to another broker. They cannot assign the showing agreement. And then there's your same acknowledgement that it's got to be modified in writing, and brokerage commissions are not set by law. Okay?
Yep.
So then I have these out of order. The showing agreement in there twice. We got a very simple modification to exclusive buyer brokerage agreement, showing agreement. So if there's any changes to the agreement, which doesn't include the type of property, okay, it's either going to be a change to the exclusive buyer brokerage agreement or the showing agreement. Termination date could change. A compensation could change. Of course, they're reminding you the broker's compensations are not set by law. The protection period could change. The cancellation fee could change. You could change the conditional termination agreement. You could unconditionally terminate the agreement or other. Plain and simple.
It is. It's really, I think it is very open to explain the buyers what we are doing, what is the value of working with an agent, what is the protection that they care, but also they know basically that we are working for them. And our time is as value as their time, the listing agent time, the seller time. It's a question here, it's getting a little confused when you are doing an open house and you are not the listing agent, or you are the listing agent and you have a buyer who comes with no agent, and sometimes they don't put they are represented by an agent, or they may not carry the buyer's agreement with them that shows that they have an agent and just coming to show an open house. So what would be the right thing to do for the agent that is holding the open house?
My recommendation is to have the buyer sign the first form.
The pre-touring
agreement? If you show them the house, then you've got to have them sign the property pre-touring agreement.
Okay.
That's required. Okay.
Mm-hmm. So, and where you are working with international buyers, they are physical, not here, but you are going to see properties for them. Also, the pre-touring, and the buyer's broker agreement.
Are you showing it to them on FaceTime?
I may or may take a video and then to show to them, because the difference of hours, sometimes
then I would have them sign the property pre-touring agreement, and I would have them sign the showing agreement.
Perfect. Okay.
Okay.
Yeah, that is basically what it's very confused, because sometimes I work with a lot of international and they are all over the place. So sometimes we are in the same time, so I can basically go and this is that.
Are you their exclusive agent?
Yeah, mostly of the time, yeah.
Then you have them sign the exclusive, the pre-showing and the exclusive. That's all. Okay. So what I'm going to see you happen, what I'm think we're going to see happen is once you start mentioning money to the buyer, before you can get it through their head that they are going to not have to pay you, that it's still going to come from the seller or the seller's agent. You just have to do the legwork to find that. They say, well, why don't I just go to the buyer's agent, to the seller's agent, to the listing agent, and let them write the contract? And that's where you're going to say exactly what you say now. Are they going to be with you there for your inspections? Are they going to go over their inspection report with you? Are they going to make sure you do your financing with due diligence? Are they going to send the notice if you don't get your financing timely? Are they going to recommend an inspector to you that is good and does their job? And that's the sort of service you should be doing.
Yeah, of course, because you are representing the seller. You are working for the seller to marketing their property and get it the best buyer. But basically, at the end, when you are buyer with both, you cannot share your obligation with both or be open to both. You will be you will be losing your listing agreement, because the seller can also say like, "Oh, are you working for me or you're working for them?" So I believe, and I'm many years in this business, and I began as a selling agent when the foreclosure time and the short sale recession time. And it is what all my database came from, because there were investors coming from outside the country, and a lot of militaries at the time were served, that I don't even see them until I gave the keys of the house. But I did everything for them. And I was working with sellers that knew also they were not here, and also with sellers that, losing their homes and everything. And we jumped all of that, and we were very open to say, this is what happened, this is what you have to sign, this is the process that we are doing this. And I don't know, over the sun, it's like a obviously we sometimes get assumed that everybody knows what you're doing. And of course, many people, for some reason, they don't like too much agents. Some of us maybe make mistakes at one point, or some of them may just not even care about what the people are working. And this is just to put in place your value as a professional. Like it's like you are going to a doctor, and you see what the doctor is and what specialties they are, and you pick them because you believe that will be helping you. Same with attorneys. You see all the experience, all the cases they have, all the availability to give some explanations. So I see some it is, I don't see it, I don't believe it will be easy. It's a transition time, but I hear about the buyer's agreement for the past 15 years, and it's there. And I use it when I work with people that just show up like, "Oh, I want you to show me this." Well, I am not a driver. I'm not showing just like I'm not a taxi to put you in my car and show you and then bye-bye. Or some of buyers, and I have to say, after you do everything, they say, "Oh, by the way, I have a cousin that is getting the license and he will be representing me." Like, and you are going like, "Oh, okay. Well, nice to meet you." So yeah, it's part of what we are as a professional, and what we want to show our families what we are doing. So
You know what, Jackie? That's all good and well, but you're going to have good realtors and bad realtors.
yeah,
You're going to have good attorneys. You're going to have bad attorneys. And even the best realtor and the best attorney will make a mistake.
of course.
So, and the best doctor. So,
Yeah.
anyway, so now we have really two more forms of any importance,
Okay.
and that is the compensation agreement. So this is what you should be submitting with your offer when you submit your contract.
Okay.
It identifies who the buyer's broker. This one is where the seller is going to pay the buyer's broker. So if the listing agent is only getting 3%, then you're going to want the seller to pay directly to the buyer's broker. And this is the form you use. Okay. So you have a term. It's going to be until closing.
Mm-hmm.
Because you don't want to say 30 days because the closing may be extended.
Yeah. Mm-hmm.
Term extends past the termination date of the listing agreement, and it tells how much the seller is going to pay, a flat fee or a percentage plus the transaction fee, okay, or other something.
Yeah.
And it's really very simple. Dispute resolution, arbitration, and broker's commissions are not set by law. Okay. And then you have the same exact agreement where the seller's broker is going to make the payment. Okay. Same thing. Seller's broker is getting 6%, so he's going to pay a portion of his. But the fact is that the buyer's broker and the seller's broker are going to sign that. And presumably, the seller's broker has that authorization in his listing agreement. Okay?
So if we don't receive if the listing agent just said, yeah, the seller agreed to pay compensation of whatever is the amount of the percentage, we have to submit both of them, or
No, just this.
the
Because
seller?
this is all that's going to be attached to your contract.
Okay.
Okay?
Mm-hmm.
And that one of them. And then in case there's a change, why would there be a change? Okay, we did an inspection of the property. We have to knock $50,000 off the price of the house.
Okay.
All right, yeah, well, I'll agree to that if the buyer's broker now accepts 2.5% and not 3%. Okay?
Mm-hmm.
So there's an example of why you would have a modification later on. Okay?
Yes.
All right, I need an extra 30 days to close. All right, but it's costing me money. I want the buyer's broker to accept a little less. Okay? So really those, and now there's this new form that came out last week. And this is the disclosure you're supposed to send to anybody that you have a listing agreement with. Quite honestly, it doesn't even call for signatures, okay?
Okay.
And it doesn't change anything, but you have a listing agreement.
Yes.
And tomorrow or Saturday, the compensation field is going to be out of the MLS. So what good is your listing agreement really? So, nobody has 1,000 listings that they can't go see everybody.
Mm-hmm.
So what I suggest is that everybody go see your listings, get a new listing agreement signed. Your listing does not expire if they won't sign a new one. You still have it, okay?
Yeah.
It's still good. And considering they authorized you to pay, they authorized that they would pay 2.5% or 3% to the cooperating agent,
Mm-hmm.
I think that gives you the authorization to continue on as if they agreed that the seller's broker will pay the buyer's broker, as long as you give them this disclosure. But go see them, talk to them about it. It's great to be in their face. And ask them to sign a new listing, and you may be able to get a couple of months more out of it.
Exactly. Yep.
So, that's who's got questions.
Well, I got the questions for the open house. That is one of the biggest one, because the rule begins on August the 17th, and this is open house weekend. So everybody was a little concerned about what we are doing. Like, are we doing an open house, or is the house open and everybody goes in? So that one is that the international. It's a find also. Basically, what would be the in the way that the listing agreement is placed, you have a full compensation, and then you can ask for sharing for you. But I hear on the conversation that we are having that the best way is just to tell the seller the listing compensation and then go to see what happened with the selling, and don't put like a big compensation for the listing agent unless it's your practice to do it, and then to go over the rules for the listing and compensation.
So, yeah, I don't have an answer to that. I'm not a salesperson. I think what you're saying is, am I going to get 6% and then I'll pay the 3%? Mm-hmm. Or am I going to take 3% and let the seller pay the 3 or 2.5? I think it would be, at this stage, it would be more receptive to the seller to suggest that I'll take 3 and you pay 2.5 or 3.
Yeah, I see that's one of the big confusion is what is the amount of the compensation we are putting on top before going to the three options.
That shouldn't change. So, I think, again, I'm not a realtor, I'm not a salesperson. I would think it's more palatable to the buyer. I mean, yeah, if you have a seller, If you have a seller that believes in you and you've won their confidence, you're going to tell them, listen, nothing's changed. 6%. No one's going to look at your house for less than 3%, and this is that. But if you got someone that's sitting on the fence, I say, listen, put it at 3% and, agree to pay 2.5%. And that'll come directly. It's still whether you give it to me or you give it to me and the other broker, it's going to come the same way. But the buyer's going to come unless someone's coming from down the street without a broker.
Yeah.
So, it's a matter of telling them how easy it'll be to sell their house at the right price, that it looks nice, and you invite the buyer's broker in with agreeing to pay their commission.
Yeah, that is all, because you have some areas that have some listings that looks like a very hard. You may present a buyer like say, I want your listing, and this is where we are going to. And I think some of the first-time buyers, they are, like you said, getting a little concerned about to put the down payment, and then they have to have closing costs, and then they don't.
Oh, that's not going to happen. That's not going to happen except in a rare case. Okay, and that's how a listing agent has to sell this.
Mm-hmm. Yeah, because some of the houses are perfect for first-time buyers, and that is the target. And if they don't go over, and depends also the seller's condition. Also, some sellers will be maybe having a tough time, and they are very close to get some trouble with mortgage or whatever. But yeah, I think it's a matter of knowing conversation, be clear, and be open to do the best work for our consumers, clients, friends, families, past clients, and future that trust us to be the person who represents them.
Okay. So if anybody has any questions, they can contact me.
You have, I have
You have listened to my BS for the past 55 minutes, so I'll be willing to listen to yours in return.
Thank you so much, Barton. You are the best. I really appreciate the time.
Let me just say that we do closings all over the state of Florida. Safe Key Title is run by 3 well-experienced real estate attorneys. Strock Cohen Zipper Law Group, also known as SCZ Real Estate Law, handles all aspects of real estate law, from buyer and seller representation, landlord-tenant, tenant evictions, some foreclosure defense now is back. There is no defense, but we try to get you the best deal as possible. Partition, deposit disputes. We're doing a lot of deposit disputes these days. And where we are, my partners are circuit certified mediators. I'm a circuit and county court certified mediator. And so I can handle commission disputes, deposit disputes. If your client is, and I'm not the attorney on it, your client's involved, you could suggest me anywhere in the state as the mediator, because those are all done by Zoom. And I'm a big fan of mediation if it's done right.
That is with my eye closed. I don't have any other option.
Okay. All right. Everybody, have a good 17th. Don't stress it out. It's very simple rules. You just have to learn that your product has been revised. Okay?
Thank you so much.
Okay. Bye-bye.